Hello everyone, I'm Aratrika Bhaumik and I welcome you all to another episode of Courts Today on LiveLaw, where we update you about all the important legal developments that took place across the country today. We will begin with developments from the Supreme Court of India and then move on to High Courts and other subordinate courts. If you like our content, then please do not forget to like and subscribe to our YouTube channel. Let's begin. A review petition has been filed in the Supreme Court against the November 7th judgment which had acquitted 3 men who were sentenced to death in the 2012 Chhawla rape case related to the gang rape and murder of a 19-year-old girl. The parents of the victim have filed a review petition stating that many crucial facts were not brought to the notice before the apex court and that certain facts were incorrectly interpreted while the convicts' appeals were allowed. A Supreme Court bench comprising the then Chief Justice of India, U. Lalit, Justice Ravinder Bhatt and Justice Bela M. Trivedi had acquitted the 3 men by observing that every case has to be decided by the court strictly on merits and in accordance with law without being influenced by any kind of outside moral pressure. The Supreme Court of India has refused to entertain a petition which sought directions to the ASI to determine the correct age of Taj Mahal and to remove wrong facts from history books regarding the monument. What kind of PIL is this? A Supreme Court bench comprising Justices M.R. Shah and C.T. Ravikumar asked today. The bench also asked how will the court decide if the historical facts are right or wrong. The petitioner then sought to withdraw the petition. Accordingly, the petition was withdrawn with liberty to file a representation before the ASI, that is the Archaeological Survey of India. Remarking that India is a secular country, the Supreme Court of India has dismissed a petition which sought to declare Sri Thakur Anukul Chandra as Paramatma. A Supreme Court bench comprising Justices M.R. Shah and C.T. Ravikumar also imposed a cost of Rs 1 lakh on the petitioner for filing a publicity interest litigation. Today, the Chief Justice of India, D.Y. Chandrachud, was made aware of the issue pertaining to benches rising for lunch at different times on miscellaneous days. The issue was raised by senior advocate Mukul Rohatgi, who stated that the issue created problems for the members of the bar who could not eat lunch at times due to the different benches of the Supreme Court of India following their own board as per their own convenience. Chief Justice of India, D.Y. Chandrachud, today, while noting the issue, stated that he will flag the same with his fellow colleagues whenever they have a full court meeting. Chief Justice of India, D.Y. Chandrachud, while holding court today, orally remarked that it was time to impose pre-hearing costs in commercial cases to prevent frivolous matters involving commercial issues to be argued before the Supreme Court of India. While remarking that such frivolous commercial matters wasted a lot of judicial time and needs to be clamped down upon, CJI Chandrachud said today, and I quote here, "The time has come to impose anticipatory costs in commercial matters which come to Supreme Court. It is time for the Supreme Court in commercial matters to say that first deposit 5 crores cost, and if it is frivolous, then the cost will remain with us." Every charity or good work is welcome, but the intention has to be checked. The Supreme Court of India has observed while hearing a petition filed by BJP leader and advocate Ashwini Upadhyay seeking to curb forced religious conversions. Justice M.R. Shah said that alluring people to convert to other religions by offering medicines and food grain is a very serious issue. The court also made it particularly clear that it was not entertaining issues with regards to maintainability of this petition. The bench clarified this after this particular maintainability issue was raised twice today during the hearing. The Supreme Court of India today directed all high courts to file their responses on the proposed setup of online RTI portals within 3 weeks. The issue arose before a bench comprising CJI D.Y. Chandrachud and Justice P.S. Narasimha when a counsel informed the bench that only 9 high courts had filed their replies in the petition, seeking a mechanism for setting up an online portal for e-filing of right to information applications and first appeals in the High Courts. The Supreme Court of India has directed the Union Ministry of Health and Family Welfare to expeditiously examine the lack of uniformity in rules regarding cadaveric organ transplant across states with the Transplantation of Human Organs and Tissue Rules of 2014. The direction was issued in a petition seeking issuance of appropriate directions to state governments for regulation and monitoring of the Transplantation of Human Organs and Tissues Act of 1994 and bringing uniformity in the rules across various states in consonance with the central rules of 2014. The requirement of obtaining permission from district magistrates before conversion is designed to shield against forcible conversions and to protect the freedom of conscience, submitted the Gujarat government in an affidavit before the Supreme Court. Such steps stipulated by the state's anti-conversion law, key provisions of which were held in abeyance by the High Court in 2021, were precautions to ensure that the process of renouncing one's religion and adopting another is genuine, voluntary and bona fide, as well as free from any force, allurement and fraudulent means, the state government has informed the Supreme Court of India. The Delhi High Court has directed the Bar Council of India to inform it about the next scheduled date of the All India Bar examination, which was conducted last on October 30, 2021. Justice Pratibha M. Singh also asked the BCI to consider having a preset schedule for the conduct of the examination so that the uncertainty regarding the dates of the biannual examination can be resolved and provisionally enrolled advocates can prepare accordingly. Keeping in view that the bar examination was not conducted after October last year, the court clarified today that Rule 9 of the All India Bar Examination Rules would not be operational for such advocates who are unable to clear the examination within the period of 2 years from their provisional enrollment. The Calcutta High Court has held that the writ jurisdiction of High Courts under Article 226 of the Constitution of India is invocable even for cases involving ordinary commercial transactions between private persons and public bodies as long as some element of public law is involved in the said commercial transactions. A division bench of Justices I.P. Mukherjee and Biswarup Chaudhary has however clarified that such invocation of writ jurisdiction is constrained only to cases involving disputed questions of fact which are not very intricate or complex and are capable of being established through evidence affidavits. Thank you. Keep watching Courts Today on LiveLaw for more such updates. See you tomorrow.